Do we have another counsel here?
Nobody checked in?
Okay, please go. You have 15 minutes. Well, I think we all did.
Do I win by default?
Oh.
Yes.
Yes.
So Ronald Ambrose, I'm appearing on behalf of Phillip Swift.
Please speak into the microphone if you would.
Ronald Ambrose, appearing on behalf of Phillip Swift. This is a request for my client to be remanded for resentencing as a non-habitual offender. The reason for it is the statute was not properly filed. There's a framework within the criminal justice system as well, in statute as well as court rule, that provides the habitual notice to be both served and filed. The service issue is basically what we're here on. At the arraignment on the warrant, there was a statement that my client was going to be charged with the habitual second, or actually habitual third, but it was never served upon my client. That notice was not served, and there was no indication within the record at all that he was served or his attorney was served. So, in essence, we're asking that my client be resentenced as a non-habitual. The Court of Appeals states, I believe wrongly, that at most fairly read that defendant's claim of appeal amounts to an assertion that there was no proof of service in the lower court record as required by MCL 76913 subsection 2. Well, it's not just that the proof of service wasn't filed, there's no record of any service whatsoever. And it's important, the reason why it's important is that notice of enhancement certainly enhances the maximum sentence that my client is exposed to, as well as under the sentencing guidelines. But also, it puts a defendant on notice as to, whether or not these prior convictions were legitimate. Did he have proper counsel?
Mr. Ambrose, you don't dispute that the underlying convictions are valid in this case. Is that right?
I can't dispute that statement.
You can't or you don't?
I haven't checked into each and every one of these prior.
Okay, well, is it fair to say that your client has never in any proceeding objected to the validity of those convictions?
That's correct.
Is that a fair statement?
That is fair.
Okay.
And this goes strict statutory construction of this.
Well, that's the question. That's why we're here. Right?
Yeah.
Yeah.
And the statute wasn't followed, and neither was the court rule followed.
Yeah, but we have another statute, right? The statute is MCL 769.26 that says no judgment shall be set aside or reversed or a new trial granted for any error as to any matter of pleading or proceeding unless it shall affirmatively appear that the error complained of has resulted in a miscarriage of justice. So that's a statute. Why don't we have to abide by that one?
Well, his conviction isn't going to be reversed. It's just
sure, but the question is a judgment or verdict. So we have here a judgment of sentence, right? That's what you're arguing about. You're arguing about a judgment of court.
Right, and there's there's a conflicting statute involved too that says that my client needs to be served.
Yeah, no dispute that there was. If we concede that there was error, we're just asking why is it not true that we have to figure out whether that error was harmless pursuant to this other statute?
It's, at the time of Mr. Swift's sentencing, the court rule provided that it would not be considered a harmless error the failure to follow the,
To file, but not to serve.
that's correct.
And you're talking, your complaint is, your complaint is my client wasn't served.
That's correct.
And it seems that the prosecutor concedes that, so they concede that there's a statutory violation of the habitual notice statute. So I think we really are on to the next question, which is whether that violation was harmless. Did your client have notice of the prosecutor's intent to request an enhancement of his sentence at the district court level?
Verbally, you got to recognize that
So at the
this was a
arraignment,
video conference.
at the district court arraignment, he was
Right.
verbally advised by the judge of his the charges and the potential sentence, including the habitual enhancement?
Only that he was being enhanced, not what the maximum was. And that's the purpose of this
And that was
piece
done-
of paper that says, well, you're now facing life, and these are the prior convictions listed as
Counsel,
to...
help me to understand something, though. I guess this is what I'm struggling with. Wasn't your client aware of this? I mean, the question is this new knowledge, or wasn't the client aware of this situation, at the time?
I would acknowledge that he was aware of his own prior convictions, and he was verbally informed that that the prosecution was seeking to enhance, but
there was no filed written notice
That's
21
correct.
days after, correct?
that is correct.
Do you agree that the filing of a written notice of enhancement is a matter of pleading or procedure?
Just the matter of the filing?
Yeah,
Yes.
the requirement itself is a matter of pleading or procedure.
Or the service thereof.
For the surface, yeah.
I'd agree with that.
Okay. Well, that's then calls into question not only the harmless error statute, MCL 769.26, which says no judgment shall be set aside because of any matter of pleading or procedure unless there is a miscarriage of justice. And our own court rule that sort of parallels that says any ruling or error is not a grounds unless the error appears to be inconsistent with substantial justice. So my question kind of is, there wasn't apparently they can't prove that they served the notice on your client, but your client, in fact, was aware of their enhancement, the desire to enhance his sentence because of his prior criminal conduct. So why doesn't the harmless error rule and the statute come into play here?
I think at the time, let's see, MCR 6.112G, and it's the last sentence of it, but it's under the heading of harmless error, and it states that this provision does not apply to the untimely filing of a notice of intent to seek an enhanced sentence. And that's...
But your complaint isn't about the untimely filing, but rather about your client wasn't served.
I
And those
think-
are two separate things, right?
Well, they are, but I think it is even more impactful
What's more impactful?
What-
I mean, this whole provision is designed to give notice, right?
Right.
That isn't really a question in this case, because from the very beginning, the prosecutor in all the complaint and information made it attached the intent to seek an enhancement. So your client was never unaware of that fact. What there is a technical violation of the filing requirement here. Correct?
He's aware that he's being enhanced.
Yeah.
Okay? And that's different, that's different, a verbal notification of,
Not verbal, it was in the papers.
it was never, it may have been filed.
Oh, so your client never saw the papers, the complaint and all that stuff?
That's correct.
Okay.
And
Well, there's no requirement that he be served with the
Complaint.
complaint or the warrant, right?
That's correct.
And that's not typically part of that district court arraignment procedure. You were, I think, suggesting that your client was actually in the jail when he was being arraigned?
He was incarcerated. They have a video arraignment system.
Right, so the question is, what was he verbally told at the arraignment?
Yeah, he's verbally told that the prosecution is seeking to
And
enhance.
Right.
And he waived a reading of the information.
And once we get into and this is how Wayne County, and just practical, how
But
Wayne
let me
County-
just be clear.
Okay.
We're going from the district court stage, the felony complaint
Right,
that he's arraigned on, but Justice Larson's talking about the information that
Right.
comes at the circuit court stage. Now, in Wayne County, that might all happen in the same courtroom. I suppose that could be true, but we're talking about two distinct stages of the criminal procedure at this point, right?
that is correct. At the arraignment on the warrant, he's being video
Okay.
arraigned.
Right.
And at that point, he is verbally told.
Does he waive the reading of the charges at district court arraignment?
I think they state what he's being charged with.
But he waived the formal reading of those charges, yes. Isn't that correct?
At the circuit court level.
Oh, at the circuit court arraignment. I'm sorry, I thought you did it at the district court arraignment.
So at district court, and again, I'll have to look at this transcript, but from what you're telling me, you believe that he was not advised of what the ultimate penalty would be, which is indicated on the notice, the notice itself that's then later filed in the circuit court, and perhaps the notice that's filed in conjunction with the complaint at the district court level.
That is correct.
And he's also not advised what convictions the enhancement is based on.
That is correct.
So it's your position that he, in fact, wasn't provided the information that he's entitled to under that notice?
Absolutely. And just as a practical matter, I do practice in both courts, and typically in Wayne County, once you get to the arraignment, or once you get to the arraignment on the information, it's typical that the prosecution will not have the actual information there. So it's typical that you will waive the formal reading, or waive formal reading of the information, or waive the reading of the information. In Oakland County,
When do you obtain a copy of the information, if not at the arraignment?
well,
You're not provided that?
not at the information, not typically. In
When your client is arraigned on an information in circuit court, your representation is that they don't serve that on you? They don't give you a copy then?
That's correct. In Oakland County, it's different. Oakland County, you go into the arraignment on the information, and it's typical that you will acknowledge receipt of the information and the enhancement notice. It's something that just does not occur in Wayne County.
So why on
why are
earth
you
would you
waiting?
waive the oral reading if you're not being given a copy? So you're just going in saying, I don't care what my client's being charged with?
I think
I don't have a piece of paper, and I don't want you to read it to me?
I think typically attorneys know what their clients are being charged with,
Oh,
but it's just a matter of what are they relying upon in order to enhance their sentence.
well, I mean, all the charges, including the sentence enhancement. So why would you, if nobody, as a matter of course, nobody gives you the information that sets out this information, including the prior convictions that are being relied upon to enhance the sentence, and somebody offers to read it to you out loud, why would anybody waive?
I think it's just expediency.
But in that case, how can your client claim, I didn't know, or nobody offered? I mean, maybe...
And quite frankly, all he's doing is, I think the specific language that was used at the arraignment on the information is that we're waiving the formal reading of the quote-unquote information. He didn't say we're waiving the formal reading of the notice of enhancement.
But that's in the information.
Could be.
Wayne County provides it as part of their information. In other counties, you have a separate form that is a notice of enhancement form.
Okay. So,
And it makes a difference because certainly he goes from a guideline range of 84 months to 140 months up to 84 months to 210 months. And if you look at the sentencing transcript, the judge initially thought that he wasn't being enhanced. And he makes a correction, 84 months to 140. Oh, no, there's an enhancement on this case. It's 84 months to 210. And he sentenced my client in the middle. If my client is granted a resentencing, I'm hoping that he'd be resentenced in the middle again, and it'll cut some time off the sentence. But the bottom line is the statute wasn't followed, and it should have been.
well, right, but ordinarily we ask whether, if the statute isn't followed, was there harm resulting therefrom? And that's what I think we're trying to...
And the harm is the increased sentence, and it's a miscarriage of justice.
Thank you, Mr. Ambrose. Any further questions?
Good morning, Mr. Chief Justice and Your Honors, and may it please the Court. I'm Margaret Gillis-Ayalt from the Wayne County Prosecutor's Office on behalf of the people of the state of Michigan. The people asked this Court to deny defendant's application for two reasons. First, the harmless error statute governs errors as to any matter of pleading or procedure. An error in complying with the notice provision of the habitual offender statute, which is in the same chapter as the harmless error statute, falls within these categories, pleading or procedure. The harmless error statute, then, is a mandate to this Court to deny relief unless the error resulted in a miscarriage of justice. Second, there was no miscarriage of justice. The intent and purpose of the notice provision were satisfied. That is, to notify a defendant at an early stage of the proceedings what sentencing penalties he faces. Defendant urges a strict compliance reading of the notice provision and asks this Court to overlook the critical fact that from the inception of the case, he had actual notice, both oral and written, that he faced sentencing enhancement. Although the people did not follow certain procedural requirements in the notice provision, this does not negate the actual notice defendant received. He cannot identify any harm or prejudice he suffered, and also cannot show how receiving valuable legal information early violates that provision. With that, I invite questions from the Court.
What's the actual notice he received?
Excuse me?
What's the actual notice he received?
He received actual notice in many different forms. At the arraignment on the at the arraignment on the warrant, the trial court read the charges and did also read that he faced habitual third enhancement, sentencing enhancement. He asked the defendant if he heard those charges that were read to him and the sentencing penalties.
Did he explain how the habitual enhancement impacted the sentence he was facing?
I'm sorry, Your Honor?
Did he explain how the habitual enhancement impacted the sentence that he was facing?
No, the trial court at the arraignment on the warrant did not. So I can continue with the other examples if the Court doesn't like that particular form of notice.
It's not whether I like it or not. I'm just trying to understand. When you say he had actual notice, the logical follow-up question is, what did he have actual notice of? And did that comport with the information that he was entitled to under the statute? And so obviously, I think the most important thing we can all agree is that the defendant's entitled to know what he's facing, right? What sentence he's facing if he's convicted.
Absolutely, Your Honor. And
All
so at the
And
habitual...
also, just so we're clear, the arraignment didn't, you would agree, the judge didn't read the convictions either, right?
Correct. The judge did not read the convictions. He did read the charges, and that defendant faced enhanced sentencing as felony firearms second and also as a habitual third offender. Defendant indicated he heard the court. Moving on to the preliminary examination, by then he was represented by counsel, and at that preliminary examination, the counsel disputed certain amendments to count 1 regarding adding the vase to the information or to the charges, and also mentioned count 3. Clearly, defense counsel there had a copy of one of the charging documents, if not all of them, and on any of those 3, the complaint, the warrant, and the information would have been the habitual offender notice.
The question is, what did the defendant know?
I'm sorry?
The question is, what did the defendant know? What was he advised?
Is it good enough that the record reveals that the attorney must have had some notice, given what you've said about the attorney's questions? Is it good enough?
Absolutely. By that point, defendant is represented by counsel. His attorney is authorized under the court rules and other law to receive pleadings on the defendant's behalf. Service on the defense counsel, absolutely, without a doubt,
Authorized
satisfied.
to receive pleadings is not the same as authorized to do the prosecutor's job about informing him about the enhancement, right? Is it
Correct.
good enough?
Our position is
Can
the
I
actual
just-
notice.
I'm sorry. Was this case resolved by guilty plea?
No, it was a jury
It
trial.
was a jury trial, so we don't need to worry. Okay. Just making sure. Thank you.
No, go ahead. Keep going. Yeah.
Well,
Well,
let me jump in, because now we're at the second actual notice you're saying was at the preliminary examination. And based on counsel's questions about the charges themselves, we can conclude that the attorney had one of the charging documents. At least you believe that. Did the attorney ask any questions about the habitual portion of the document, or the habitual? I don't know how it's done in Wayne County. There's a page, I guess, a separate page, from what I could tell, where the habitual. Because it is true that the county I'm from, Macomb County, it's provided on a separate form.
correct. So first of all, the habitual offender notice is not on a separate page. It happened to fall on one in this case because of the spacing of the paragraphs, I presume. But no, the habitual offender notice is always included on the charging documents from the inception of the case. And I think that people deserve, that needs to be given a lot of deference and acknowledgement here that we are trying to comply with the due process component of the habitual offenders statute by giving early notice
You weren't trying very hard
of
in
that.
this case, right? Because
I'm sorry?
You weren't trying very hard in this case, or else we wouldn't be here, because you didn't serve the notice, right?
Well, I agree that procedural requirements were not followed, but we contend
Well,
that
I just challenge you a little bit on the idea that we should give you deference when you haven't complied with the statute. That's why we're having this conversation. So the question is, how do we know that the defendant had actual notice? And so you've said now at the exam there was a discussion of the charges, and from that we should conclude that the lawyer had the charging document, and attached to that on page 2 was the habitual notice. Is there any other way that we should know or conclude that the defendant had actual notice?
yes. So first of all, there was the preliminary exam where the defense counsel discussed the charges. And yes, absolutely, service or actual notice can take place. It's fair to assume the defense counsel had a copy of the charges. Therefore, he was certainly able to inform his client of the habitual offender notice.
Anything else beside that?
Did that happen at circuit? Do you have a circuit court argument too with respect to the waiver of the
Yes,
circuit
and
court
moving on
arraignment?
to the arraignment on the information, again, defense counsel waived the reading of the information. At sentencing, defense counsel, the mention of habitual third, and defense counsel did not act surprised, defendant did not speak up about
Hold
anything.
on, I want to slow down. You're going way too fast for me.
I'm sorry.
Back to the arraignment on the information. Defense attorney waived the formal reading. defense counsel said that your office does not provide defendant with a copy of the information and the habitual notice at the arraignment on the information. Do you agree with that or disagree with that?
That is generally the practice in our office, yes.
Is there a reason why? Is there not a requirement that you provide the defendant with the copy of the information, the charging instrument, and the habitual offender notice at that time?
Yes, there is a requirement, and we are,
So as a matter of office policy, your office violates the statute?
we contend that the actual notice gives more than enough notice to the defendant on a due process.
Yeah,
So you don't
but
follow
there's a
the statute?
statute that
Yes.
says he has to be served.
We would, absolutely, and we.
You
we
think that's a good idea?
No, Your Honor, we're
I hope you
implementing.
fix this.
Excuse me?
I hope you'll fix this.
We are implementing procedures, absolutely, Your Honor. We are implementing procedures to,
Follow the statute.
To follow the
Yes.
law?
Oh,
Can I just
that-
ask- can I
That's
just-
nice for prosecutors to follow the law.
Can I just ask a simple question?
yes.
Why don't you do it? Like, why are you implementing procedure? I guess I just would like to understand, like, so why didn't you just do
Is it
this?
just like saving copying costs, or what's the?
I mean, what was the reason?
Is it because everything's harmless error?
No, I cannot represent that it's a good idea. We,
But the question was, why, I mean, to the best of your knowledge, why wouldn't you just do this?
and that is why we're implementing procedures to change this. We became
But it
aware
was
of this.
because of this case that you're implementing. I mean, why did this happen for the time that it happened? I mean, I guess I'm just trying to understand, like, why did this happen?
Because of our office policy,
Okay.
there had not been previously a policy of serving defense counsel with a copy
Or
of the
following the
information.
law.
So I just have to,
The procedural requirements, yes.
so what you're telling this court that's happening in Wayne County is your office is not complying with the statute that requires them to serve the defendant, but defense counsel also told us that defense counsel routinely waives the reading of the information. So basically, neither the prosecutor nor defense counsel thinks that the defendant ought to be informed of the charges. That's what's happening in Wayne County?
Well, several things. I can't
Because
speak
that
as,
doesn't seem real good.
well, the way Your Honor has put the facts, I would agree with that. But there are several
Are there any
things.
other
would you put the
statutes that are there just out of are there any other statutes that we should be aware of that maybe aren't being followed that you know of?
That's not the facts before the court this morning,
Fair
and
enough.
my
All
honest
right.
answer is no
Why,
at this
why do
moment.
why can we apply harmless error under these circumstances? The facts are, as you've asserted, there was an oral reading of the fact that enhancement was being sought at the district court level. But does the, refresh my recollection, does the enhancement form tell you what the
Specific convictions are.
yeah, the conviction, tells you the convictions, but it doesn't tell you what the sentencing guideline ranges are, does it?
Well, it couldn't because they haven't been calculated
Right,
yet.
okay.
So, and it's
So
not
it tells
required.
you the impact on the maximum sentence, right?
I'm sorry, I didn't hear, Your Honor.
Tells you the impact on the maximum sentence, right? Penalty, twice
Correct.
the
It tells you
maximum
the
sentence.
maximum possible sentence. It lists the convictions and the dates. I would like to respond to Justice Larson's question, however.
No, you can, but I'm trying to understand what the actual knowledge here is.
Justice Larson, do I need to arm wrestle him?
No, it's okay.
I just want to confirm, the actual knowledge is confined to the oral presentation that you've described at the district court level.
Well, no, we would contend that the defense counsel at both the preliminary exam and the arraignment on the information had a copy of one of the charging
But not
documents.
because you got any, you gave it to them.
Correct, not because we handed it to them. However, we are the
You can
ones,
answer a question.
we are the ones who put the notice from the inception of the case on all three charging
But
documents.
you're essentially arguing the lack of objection to your current procedures, whatever their lapse in terms of what the law requires, is harmless error because nobody's objected. They feel that essentially they're getting the gist of things through some other means. Is that right?
Not exactly, Your Honor. I'm not here to excuse the failure to comply with certain procedural requirements. I just want to draw a distinction between the habitual offender statute codifies the due process right to early notice. And the legislature, and we respect that provision, and acknowledge, if you don't believe we respect it, we acknowledge that it is certainly, it's a law that we need to follow. But the component of the habitual offender statute regarding the filing of the notice, we never violate that. And if we did, if we filed a notice on the 22nd day after the AOI, we lose. We acknowledge the filing is the critical key. We contend that the fact of notice, which we always give, we give it on the charging documents, is distinct from the manner of providing the notice to defendant, and that manner should be reviewed under a harmless error standard. The manner of providing that notice, in this case, was actual notice.
But what is the purpose of the additional requirements in the first place from your point of view? I understand, I mean, they're discrete requirements, and you're saying you comply with the first set of requirements, but perhaps not as religiously with the second set of requirements.
Correct.
What do you understand to be the legislative purpose behind having both of these sets of requirements?
Well, I think the legislature, again, the purpose was to set forth specific procedures to follow to, in fact, provide notice to a defendant at an early stage of the proceedings. And the people do this. I'm not excusing the failure to serve, but I do think it's extremely distinct from the failure to file a timely notice. And I would point out that in People v. Ellis and People v. Morales, the bright line rule, both of those cases involved the issue of filing. There's no issue of filing here. Both of those cases did not even mention service. The issue of service was not before either court. The bright line rule applies to filing.
But counsel, do you think that, I mean, I guess my question would be, and I realize this is a difficult question, and you're doing a very good job because this is a tough situation, so I realize the challenge of this question, but if you're aware that there's a problem here and that you're not living up to the statutory requirements, do you feel that there should simply be no consequence for that?
Your Honor, no, we don't. But we would again assert, and I don't mean to skirt the issue, I'm backing up a moment, we are urging a harmless error rule applied to the failure to service, and it's a case-by-case basis. It depends on the actual notice a particular defendant received. Certainly, we're not saying across the board, you know, ignore the whether defendant was served or not. We're saying on a case-by-case basis, you are mandated by the harmless error statute to deny relief unless there was a miscarriage of justice. We go back to the standard of harmless error, and there simply cannot be any conclusion that there was a miscarriage of justice here when the defendant was aware of his prior convictions, was told on the record that he faced habitual third sentencing. It was raised at sentencing. The defendant and his counsel did not object. And I would like to point out that on September 6th, at the end of trial, defendant himself, sua sponte, asked the court a question, wanted to let the court know that he was unhappy with his counsel and wanted to raise an ineffective assistance claim. And he mentioned two things: failure to call witnesses and failure to allow him to testify. He knew he was a habitual third offender. He did not raise lack of notice to the court, number one. And number two, this shows a defendant who was clearly comfortable expressing himself before the court without even being prompted. At sentencing, the trial court directly asked him, "Do you have anything to say?" "No, Your Honor." And when the sentence enhancement was mentioned, all defense counsel said was, "Well, we recognize that it's discretionary with the court." That is all that was said. There was no miscarriage of justice here, Your Honors.
Okay, counsel, your time is up.
Thank
Are there
you.
any further questions? Okay, thank you very much.
Thank you.